that we heard the testimony in regards to the motion.
Gotcha.
Yes, Your Honor, we began
I'm sorry.
this motion to have the child testify.
Okay, yeah,
And there were
gotcha.
some things there, so I had to pull up my computer, I was having some issues, and I have all my notes in there as well, where there were several exhibits that were entered, Your Honor. We had 11 exhibits that were entered, most of all pertaining to Dilara. And in regards to that, we heard from, as you stated, those witnesses, but we also, I have all of the exhibits listed out that were presented from the IEP. Ms. Regulate presented the notes from Kerry Loy. We were in the process of it, Your Honor, but I think it was muddy as to whether or not we were hearing about the actual material change. We began the process saying that we, whatever the openings were, that was my position from what I'm recalling as I review my notes, because I couldn't get in them.
All right, well, let me just do this. To unmuddy any waters,
Yes, ma'am.
I'm going to start all of the proceedings over again.
Okay.
I will allow any of the 11 exhibits that have been previously entered into the evidence to be re-entered into evidence without the, I guess, evidentiary breakdown that needs to happen. If they were already properly entered in our one of the 11 exhibits that were previously entered, then they will be in a timely fashion allowed to be re-entered again. So for everybody's purposes, I'm starting this day trial from day one. I have 2 brand new attorneys. We will start everything from afresh. The 11 previous exhibits that were entered into during the May hearings will be allowed to be entered into again as part of anybody's proof in case. As to the 2 contempt petitions, the A.C.E.s, whatever they are, as to the 2 contempt petitions, I like that, I'm sorry.
That's funny.
The A.C. 223-885 and 223-883, you are saying you are wanting to strike or dismiss those petitions.
Well, I think one also, I'm sorry, Your Honor, one of them also has a custody modification, so we are just not going to proceed on criminal contempt, and especially in light
So
of the
as to
fact
the-
that we've got a no-show witness.
As to the contempt
Contempt
petitions,
bar,
you are
of course.
dismissing. So the complete pro se contempt, which is the A.C. 223-885, that one will be dismissed. That's the pro se one.
And I think Ms. Regularly adopted the parts by reference that she felt like were relevant. She's even got the same dates, same allegations. So I think that, yes, yes, Your Honor, we're sufficiently covered by Ms. Regularly's petition.
So you are dismissing this petition. Okay.
And incorporating, proceeding on the modification of custody portion of the one that's kind of a combo.
Okay.
You know.
So the
I don't
second
think those
one-
actually separate mine, but.
The second was
For this
AC 223-883, which was mother's petition for contempt and for modification of the parenting schedule
Yes.
against the father. So you are dismissing the portion of the petition as to the contempt. However, you are proceeding on the modification of the parenting schedule against the father.
Exactly.
Okay.
And same, making sure no allegations are dismissed, only as to relief.
No, Your Honor. All allegations of civil and criminal contempt need to be dismissed, or we need to have a hearing prior to the custody matter. They need to be dismissed with prejudice.
I think Ms. Cheatham, that's kind of asking for, let me, I think that's asking for your cake and wanting to eat it too, and I think you have to dismiss the portions of the contempt, or you have to go forward on the contempt.
No, we're saying the relief, the allegations supporting the contempt and modification are the same. We will dismiss with prejudice, seeking any relief as to contempt, criminal contempt. So in other words, the same allegations go to a modification. particularly the portion of the modification statute that, talks about whether or not he has supported a relationship with the other parent.
All right, anything else, Mr. Frakes?
Obviously, I have no objection to opposing counsel using the allegations against Mr. Gideer to try and bolster their case as to modification of custody. I just want to make sure we're clear as to civil contempt as well as criminal contempt. There will be no allegations based on those factors at the end of this hearing.
Okay.
They're dismissing all civil and criminal charges against him with prejudice.
That's correct.
That is
All right.
correct.
All right, so then we will go forward. Now, and I guess before you get to that point, normally, now that the contempts are gone, I would start the proceedings as to the first filed petition. And so that actually would be the father's first petition to modify, which was the one that was filed, petition number 2222960. And that was the father's petition to modify that was filed in October of 2016. I think the mother's petition was filed in November of 2016. Both her private party petition as well as her, attorney filed petition.
I'm ready to proceed, Your Honor. We have no objection if opposing counsel chooses to go forward on hers first. We have no objection as to the order.
You don't care who goes first?
No, ma'am.
All right.
We'll just allow the
Okay.
the original petitioner, Your Honor. I do want to announce to the court that we have located Ms. Mullins. She still is with Camelot at a different location, so we do anticipate being able to call her. And just one more brief housekeeping. Ms. Reguly's motion, pretrial motion for telephonic testimony from Ms. Kerry Loy, it is my understanding that neither counsel objected to that, and that was also taken up as a preliminary matter as well, and that she will be testifying.
I'm sorry, say that one more time.
Kerry Loy,
Okay.
Ms. Reguly filed and served on council on May 2nd, and does this help to do this PT number, AC223?
Not necessarily.
It's just mother's pretrial motion for telephonic testimony, for taking the testimony of Kerry Loy via telephone. She is located in California. Her testimony in Ms. Reguly's petition is material, relevant, and crucial to a full adjudication. That was served on both counsel, or the guardian ad litem and counsel, May 2nd, and I think the guardian ad litem tells me that there was no objection and that we will be hearing from Ms. Loy at some point.
Okay.
And Your Honor, we were supposed to hear from Ms. Loy on the 16th, and
Gotcha.
that was the plan.
Right.
Because we'd already, so I don't know how you.
I kind of train wrecked the.
All right, so Mr. Frakes, I guess, as his previous counsel, I think that there was no objection to that.
No, Your Honor.
Okay. All right. Any opening statements, Mr. Frakes?
No, Your Honor, just before one more preliminary issue. Yesterday, or on the 16th, Your Honor, it stated that we would go from 9 o'clock until 11:45, I believe, and then break for lunch. Are we going to maintain the same schedule?
Correct.
Yes, Your Honor. No opening statement, Your Honor.
I would like to make a brief opening statement, Your Honor.
Okay.
I think the court went through the procedural history, and by naming the allegations that are currently before the court. For our purposes, Ms. Hubbell has concerns that she, for one thing, the amount of time and the portions of her child's life that she has missed is very traumatic. And we have an expert, and we intend to, at some point, amend the certificate of readiness to include the expert. But there's a study out now, and I think the court can take judicial notice because this court deals with traumatized children every day, and it's called the A.C.E.s study, the Adverse Childhood Experiences. And very high, and those are where, over a long term, a group of folks who study children and children's issues went in and quantified the types of trauma to children and traumatic events that children experience. And they called those adverse childhood experiences, and they rated those. And they looked at the effect that certain types of events have on children over a long period of time. And very, very high on that list is sudden and dramatic changes in their contact with their primary attachment figure. I see nothing in this record that disputes that Ms. Hubbell was Dilara's primary attachment figure during the first 5 to 6 years of her life, and that they had a very strong and healthy bond. Ms. Hubbell, I think the court will hear, and is maybe already aware, has raised 2 excellent children. One, I believe, is in their second year, third year at Vanderbilt. The other one graduated with honors from Hume Fogg, a school my mother went to, oddly. But she has raised 2 children. She has suffered with some physical ailments. She has had some trauma herself, mostly related to this type of litigation. I think that there should be some concerns and some eyebrows raised. We've looked at Ms. Hubbell a lot, put her under a microscope, and I think any of us in this room who've ever parented children get put under a microscope. We're going to be seen to have made some mistakes, done some things we wish we hadn't, done some things we're proud of. But raising 2 excellent children would be high on the list of something to be proud of, and to demonstrate a history of being able to effectively parent children. Now, Ms. Hubbell enters into a relationship with Mr. Gadar. It breaks up before Dilara is even born. And there's already, becoming objections to things like homeschooling and these types of just almost exerting power and control over mother and child. And I think anytime a parent goes to extraordinary lengths to separate a child from their primary attachment figure, at some point we've got to look at them. Now, there were some disturbing, in the recent restraining order, which is before this court now, Judge Smith was very clear that he was sending it over here and that it was modifiable, and, all orders related to children should be temporary in nature. But that restraining order, in the restraining order, he noted that there had been a sudden and dramatic separation from this child, between mother and child, and we were very limited in what testimony we were allowed to present, but we were able to look at Dilara's school records. They are increasingly more and more violent and disturbing, and I believe that, and it's my understanding, I've spoken at length with Dr. Berryman. Dr. Berryman and I have a very long-standing professional relationship. Dilara wants to see her mom, and Dilara needs to see her mom, and she needs to see her mom soon. I have had trial courts on several occasions say, when we leave here today, this is what we're going to do. We're going to go to McDonald's. We're going to set up these parameters, and this mother and this child are going to see each other, and they're going to visit. Now, for the last several months, which, very procedurally muddy, jumping over to another court, and I think the fact that the failed attempt at having this child placed under a 5-year order of protection in which she would have been completely cut off from her mother should weigh heavily against Mr. Dilara. I understand he has concerns, but Ms. Hubbell's concerns so far are kind of getting shuffled to the bottom of the deck, so to speak. So we are hoping that the court will let us fully vet her concerns, her strengths as a parent. We're not here to do parent bashing. We should be here to build these parents up and say, what has she done? She was told to do this, 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 and this. She did it. She has a picture of a completely neat and appropriate room ready for Dilara. Right now, she shared it with the guardian ad litem. The court said to supervised therapeutic visitation with the agency Camelot, and she did that. She did what she thought she was supposed to do. Ms. Mullins transmitted information to her, which caused her to fully believe she had completed that and was ready to move on. Camelot, and we believe the proof is going to show, support that belief. You're ready to move on to the next phase, and the next phase, and the next phase. We feel like at this point, absent continual interference, she would be having regular, typical parenting time with her daughter. She never sought to cut Mr. Godard out, and I don't know what the explanation is, but one of the disturbing behaviors that has developed while my client has been absent from Dilara's life is she's starting to grab other children's breasts and doing completely inappropriate and showing very poor boundaries types of behaviors in school in addition to the violence. I don't think there is a person, a professional, anybody in this case that would come into this courtroom and say that Ms. Hubbell has done anything that would warrant cutting her as one of the witnesses that we would like, we hope we're going to be able to present with an amended certificate of readiness, calls it a parentectomy, cutting that parent out like a useless appendix. That is not what this court's goal is, according to these orders, according to the guardian ad litem, according to everything that I've seen and read. It is, how do we get this mother back incorporated into this child's life, get her on the footing that every parent deserves to be as a part of her life, involved in her birthdays, her Christmases, important events at school. She tried to go to the school and have lunch with this child. Mr. Godard gave them this arbitrary list that he created that appears to be only in his mind. She can't do this, she can't talk about that, oh, look at this order, and those types of things. She didn't do that to him. So at some point, I think we've got to say she has taken every step that she's been made aware of through the court. Yes, she had some conflicts with an agency that she had no problems with until Mr. Godard got a hold of them. She has had some issues with the school, which she had no problems with until Mr. Godard got a hold of them, speaking in their ear, telling them she can't do this, she's not supposed to do that, and they look askance at a parent that has been very heavily restricted from their child's life and kind of turned on her. So she is willing to and ready and able to redevelop those relationships, reestablish the relationships with the important people in her life, in her child's life. But number one, primarily, the top of the list is getting her back into this child's life, out of which she's been cut almost completely, to an extent that is rarely seen. I mean, there are people that leave prison with felony charges that are serious and violent, that don't have the kind of restrictions that have been placed on her, primarily from the other parent. And we want the court to consider that, and we want the court to immediately start this mother's time back with her child. Thank you.
Right. And Ms. Mack,
Your Honor, if I may at the end respond.
you may.
Good morning, Your Honor. What has changed? October 2015, this court laid down a specific order that provided that there would be therapeutic visitations, at least there would be supervised visitations. Originally, the plan was to where the mother, to go on for at least 2 months, but the mother would present herself in an appropriate manner to warrant going up to unsupervised visitations. This court has a history of knowing cases that even when A.C.E.s is involved, the process to begin unsupervised visitations, the parent has to present themselves in an appropriate manner to warrant any unsupervised visitations. The proof would show, and has shown, that since Camelot has provided these services to the mother, that we've had several issues that have taken place. Now, one would argue that these issues have taken place because the father's interference. But let us be clear. October 2015, this court laid down an order that the mother would only have therapeutic and or supervised visitations and would present herself back for that to be modified. What has changed in 2017? We are now in October, 2 years later. What has been the material change of circumstances to warrant any change in that original 2015 order? It is the guardian ad litem's position that in regards to the changes in that original order, nothing has changed. We are simply at the same place that we were in 2017 with the mother's compliance, with the mother doing what she needed to do as we were in October 2015. Where are we today? Where's Dilara? The proof has been clear that Dilara has had some issues. She started out as just a gifted child. The proof has been clear and will continue to be clear based upon every testimony from every therapist, every psychologist, every teacher. The proof has been clear that Dilara has now had the need of, since April of 2017, to be under the classification of ED, emotionally disturbed. She didn't originally have that, but there's also been testimony, Your Honor, that has stated that no one can determine the actual cause, if it's the father, if it's the mother, or if it's just the child. No one can come into this courtroom and say that this court's order preventing this child from having unsupervised visitations with her mother. The court never restrained the mother from having contact. There's never been an order set down that said no contact with Lydia Hubbell. No order has ever been issued. There's not been a change. We have all consistently said we are agreeable to supervised visitations. The testimony will be clear that everyone, we had even asked the prior guardian ad litem to supervise visitations in an effort to help this child and the mother to have the visitations. But we still continually had defiance and disrespect from the mother. Even in 2015, if the court will recall, when the court asked Ms. Hubbell, what is the difference in Mr. Gadare determining how the child's education should be done versus you? Her testimony was because she knows better. It's not that Mr. Gadare can't do it, but it's because she knows better. And for the entire duration of this trial, what has been consistent and what has not changed in that aspect is Ms. Hubbell's consistency and persistence on her knowing better than everyone else, to the detriment of Dilara. We've had visitations. The proof will show that there were visitations where it was video. We watched it on video, Your Honor, where it showed at the library where a visitation ended, where Dilara is sitting next to her mother while her mother is refusing to release the child, even with law enforcement coming. We have had consistent to where what we've been asking is for the mother to just say, baby, I'm going to go do what I need to do, and you just wait for mom to do what she needs to do. Just wait for her to do what a reasonable, prudent parent would have done. Is to say, let me go ahead, let me keep you out of this. Let me not tell you what's going on with the court case or what's going on with mommy and daddy. But let mommy work it out. We've been waiting for 2 years for the reasonable, prudent parent of Ms. Hubbell to operate in that manner. And yet, We're still here today, 2 years later, and Ms. Hubbell is attacking the father for doing what is best for the child, but still, not the father preventing, court orders. We now have, and the court will take judicial notice of this, we have a restraining order from Third Circuit Court. This case in 2015 was also in Third Circuit Court for domestic issues, where the mother was incarcerated during that time.
Your Honor, I'm going to object to any reference there. Ms. Hubbell has absolutely no criminal record, so I think it's totally inappropriate for this guardian ad litem to start almost testifying about what went on in Third Circuit. She wasn't even there. There are no
Your Honor,
criminal.
these are
There
all
is
documents
no
in the
criminal
record, and
conviction.
there is testimony that they filed something to continue the order of protection, Your Honor. I'm just going from the original piece, Your Honor.
Overrule objection.
So this all started with the mother appearing at the father's house, being aggressive and whatever, because she didn't like the way things were done. What we've asked, this court has set down an order, Third Circuit has set down an order now, asking this mother to not do these things to cause emotional harm to her child. I can tell you today, as guardian ad litem, what has been proven by this trial since 2015 and now 2017, that Dilara has emotional issues. That's what's been proven. But will Ms. Hubbell admit that she is a contributing factor to some of the emotional disturbance that this child is dealing with? No. But the issue where we are today is we have consistently said, Ms. Hubbell, you find us a supervised visitation person that everyone can approve of. We're now in October 2017, that has yet to happen. Life Care refuses to do the supervised visitations. Camelot refuses to do the supervised visitations. Then the mother presents to her new attorney, Ms. Cheatham, that, oh, we've done something defiant and hurtful to her, but yet when we originally started this, we started with Life Care supervising, but the mother could not afford the $50 at that time to pay for the supervised visitations. So we opened a FCIT case so the Department of Children's Services could pay for that to help this mother be able to have this contact with her child. We didn't know that it was going to go on this long. We didn't know that it was going to go on beyond 2 months and we would be into 2016 and we're still having therapeutic visitations. We didn't know, but here's where we are. We did these things to help Dilara visit with her mother. So then we come in and we get attacked because Ms. Hubbell says we've done something to violate her. We put in every resource that we know how to put in to help her visit her child. Even to the point of this mother emailing other people to say, will you supervise this? We've asked CASA the willingness to come back on this case because we originally had CASA. Would you be willing to supervise the visitation? So everyone can see that Lydia is showing appropriate parenting skills. Tracy Rose, DC Camelot supervisor. Has there ever been in any Camelot notes where the mother has displayed anything to say, any recommendations where she is ready to move towards unsupervised visitations? Corporate, no. There has not been any documentation, there has not been any recommendation, and no one has testified that the mother has complied to where they are satisfied that she is ready to move towards unsupervised visitations. No documentation, no notes, no exhibits. Of those 11 exhibits that we have presented on May 10th and May 12th, no one said the mother has complied. In fact, what we've heard consistently is the same thing we heard in 2015. She has not complied. So what has changed? We're here today, supposedly, to my understanding, is whether or not there's been a material change of circumstances to warrant any change in the 2015 order. The 2015 order hasn't been complied with as of yet to even warrant a change. The court, in its efforts, understood that Dilara wanted to see her mother in 2015. The court understood in January, in February, and every month understood that Dilara, by this guardian ad litem standing before this court and saying, Dilara wants to see her mother. When asked, guidance counselor, teachers, what does Dilara communicate at school? I want to see my mother, but maybe once a week. I don't want to live with her, but maybe once a week.
Your Honor, now, this is inappropriate, and her testifying on behalf of this child that she barely knows, and it is not appropriate for her to be giving testimony.
Your Honor, these are facts that have been presented. These are testimonies that have been given, and it's my job to present what my client wants. And that has been clear and consistent through the therapists, as well as the school psychologists and the teachers. Your Honor,
This is opening statement is getting a little longer.
that's what the proof will show.
Okay.
So, here's where we are. Even if the court were to find that there has been a material change of circumstances, then we have to look at whether or not it's in Dilara's best interest that there be any change from removing her from where she is, where she's living right now. It is this guardian ad litem's position, and it still remains, that Dilara needs her mom. But she needs her mom to stop writing chalk things on the outside of the courthouse. Stop posting signs all over. Stop with the YouTube. Just stop doing the things that will cause additional psychological harm to her. Just love her. Even with discussions, even with her prior attorney. Just focus on Dilara. Let it not be about what Mr. Gadara has not done or what he needs to do. Let it be about, hey baby, how are you? This guardian ad litem, what she believes is in Dilara's best interest and what Dilara wants today, Your Honor, is the same thing in 2015. The mother to make everything healthy, emotionally healthy, psychologically healthy about Dilara. The focus and do whatever she needs to do to comply to do what's in Dilara's best interest. And I do not believe that we have had compliance with the 2015 order to even modify anything in this order other than to restrict the mother from having any contact, but we're already there. That's my position, Your
All
Honor.
right, and then Mr. Frakes.
Thank you, Your Honor.
Hey, can I ask the guardian ad litem just for one small clarification? Is she saying she wants to continue for Dilara to have no contact with her mother?
Nobody's ever said that Dilara had no
That's what I
contact.
thought she said at the very end.
Do I need to clarify, Your Honor?
Oh, I would like that, a clarification.
Go ahead, Mr. Frakes.
Your Honor, in response to the mother's opening statement, one thing that the mother won't disclose to the court is that she didn't raise the two kids primarily, that she references the older children. Their children that were awarded custody, to my understanding, her ex-husband raised the children primarily. It's not been the mother raising the children. The whole issue that we're here before this court, Your Honor, is the mother refuses to accept instructions or accept responsibility for any of her actions. Everything is someone else's fault, primarily the father, his former counsel, myself now, the guardian ad litem, this court. Those are all persons that she openly attacks and makes false statements about on social media and everywhere else. The mother has endangered the mental health of the child by posting signs in front of the school, protesting the signs in front of the school, throwing colored rocks, painted rocks into the school playground where her daughter will find them, chalking sidewalks at playgrounds where her daughter will see them with her daughter's name to bring Dilara home. The mother's went so far as not to only do these actions towards her own child, she's started some type of a movement with 3 other adolescents that she babysits and has those children make these rocks, these signs, these posters, these fans. This court has entered an order previously that specifically finds that Camelot's supervisor has stated that the visitation with the child and the mother has not gone well, that the mother continues to bring up inappropriate conversations with the child, has become abrasive, doesn't abide by the rules, and that the police were actually called for one visitation issue with Camelot. Camelot no longer will supervise her visitation. Life Care has had the same issues, except Life Care actually had to have the police come and arrest the mother for criminal trespassing.
And again, Your Honor, I'm
Which
gonna
does
object, all of
have a
those have been
criminal
dismissed. This, my client has no criminal record whatsoever. It's inappropriate to
I
keep
will-
bringing that up.
I will overrule the objection. I think it goes towards, first of all, it's opening statement, then I also think it goes towards the mother's following the rules.
Further, there has been the expert opinion of Dr. Merriman in previous hearings, Your Honor, who has stated that the visitation is not gone well and that she does not recommend unsupervised visitation for the mother at this time. That's been the only expert opinion, in my understanding, that's testified in this matter. The father is asking that the mother, prior to going to the father's issue or petition, Your Honor, as to the mother's petition, the guardian ad litem is correct. There has not been a modification. This order of March 2017 specifically states that there was some confusion with the mother's interpretation of the order. Court clarified at a prior hearing that unsupervised visits were not to automatically begin after mother completed 2 months of supervised visits. Rather, it was the court's intention that the supervising agency would have to specifically indicate that the mother was ready for such supervised visits. The only supervising agencies that have been involved in this matter, being Life Care and Camelot, have both stated that they will no longer supervise the visitations of the mother due to her noncompliance. There is nothing that the mother can present to this court to show that she's complied with the court's order. There is no modification based upon the mother's petition. The father's petition does ask that the mother's parenting time be terminated temporarily in whole, Your Honor, until such time as she would show this court that she's taken the appropriate steps to parent this child on an unsupervised basis without damaging the child's emotional well-being. The acts of the mother are damaging to the child. That is the only reason this child is acting out in the way she is. She wants to visit with her mother, but her mother is mentally damaging her by her acts. The mother refuses to comply with anybody's recommendations, and the mother refuses to forego discussing the litigation with the child or the issues. Both agencies have reported that she's done so, Your Honor. The only alternative at this time is to suspend the mother's parenting time temporarily until such time as she's able to show to this court in some manner that she's prepared to go forward with supervised parenting time without being a harm to the child.
All right, thank you. All right, you want to call your first witness, Mr. Frakes?
Simon Gadir, Your Honor.
All right. Have I sworn everybody in yet?
I'm
All
doing
right.
so, Your Honor.
If I get, I guess Ms. Hubbell, Mr. Gideon, y'all will stand and raise your right hand.
Do you swear to tell the truth, the whole truth, nothing but the truth, help you God?
Yes.
I do, yes.
Would you like me to approach the podium, Your Honor?
It's up to you. You can stay there. I know all y'all have lots of stuff, so it might be easier to stay wherever you are.
Your Honor, permission to slide Mr. Kadir and come up.
Yeah, that's fine.
Could you state your name for the record, sir?
Sinan Gider,
And Mr. Gadir, you are the father of the minor child at issue, correct?
yes, I am.
And the child's full name is?
Abigail Dilara Gider.
I'm sorry?
Would you repeat that for opposing
Child's
counsel?
full name is Abigail Dilara Gider.
Did you provide the information contained in the petition for modification to your prior counsel, sir?
Yes, I did.
And to the best of your knowledge, is all that information true and correct?
Yes,
Pursuant to an order of this court, are you currently the primary residential parent of the minor child at issue?
yes, I am.
How is Dilara since, previous to this, did you have a order of protection taken out against the mother?
Yes. On June, myself and the child were under order of protection for 1 year from June 15, 2015 till June 15, 2016.
And what was the basis of that order of protection, sir?
Object to relevance.
Your Honor, it's relevant as to the custody issue.
I guess my last order was October of 2015. I believe I've heard most of the orders, but I'm going to sustain that.
How long was the order of protection in effect, sir?
For 1 year.
Well, he
It's
asked.
a different question, counsel.
What was relevance of the order of protection?
Does counsel have an objection again? Make it, please.
I'll
You
overrule,
asked counsel not to address me.
I'll overrule that one.
When did the order of protection expire and the mother's parenting time resume, sir?
June 15, 2016.
And at that point in time, what type of parenting time did the mother have?
Supervised visits up to 4 hours, I believe.
At what point in time did you begin noticing any type of emotional issues with your minor
Object
daughter?
to the leading, no, and lack of foundation.
Did you notice emotional issues in your daughter, sir?
It took me to realize that the child was declining mentally and emotionally. You don't notice it after the first visit, but I noticed it after a while.
And is this after the parenting time of the mother was reinstated?
Yes, after,
Object to the leading,
When did this occur, sir?
June 15, 2016, the order of protection expired and mother started her supervised visits within 2 to 3 weeks.
Did you notice a change in the child's behavior in your residence?
it wasn't like obvious when can I say what child told me when I first picked her up from, no.
No statements as to the child. What did you notice with your own person, or what do you have personal knowledge of, sir?
Yes, child, like for example, I used to use children's playroom all the time as a single parent. That was like my go-to place anytime I need childcare. I can bring my bank statements, like you will see many charges from that place. But after child started seeing the mother, she started kicking and hitting other kids over there. Now I cannot take the child to that place anymore. I mean, when the child was under order of protection, I constantly use that place. She would like that place. When I go to pick her up, she wouldn't want to leave because they have like games and things. But now I cannot take the child to that place anymore.
Have you noticed a correlation between the child's behavior after she visits with the mother or previously visited with the mother?
Have you noticed, your response, or you have a response?
I don't believe it's leading, Your Honor. I'm asking
I'm
if he's
gonna roll
noticed
that
any.
one.
I think the most obvious thing, like we asked the certified school records for the child. During the 2015-2016 school year, when the child had no contact with the child was on honor list. I have the copies of her awards, Your Honor. Child never missed school. She had perfect attendance. And after she started visits with the mother, child couldn't even stay in the classroom. She would run out. She had lunch with the child on August 30th, unsupervised, against the court order. 2 days later, child broke teacher's toe. 2 days later. Next day, child couldn't go to school because child had full-blown diarrhea.
Your Honor, could he not
Have you
address my
personally-
client? He's turning to her and
This
yelling.
guy, if you'll just look at me.
Yeah.
Have you personally noticed a change in your daughter's behavior after she's had visitation with the mother?
Yes, it was like a.
Asked and answered.
Yes, I did.
3
I mean,
times.
all these. I'm not the.
Your Honor, and I do apologize, I've never seen Mr. Gadare get this upset. He's become rather emotional. Can we take because she agitated me earlier, and if you take a little 5-minute break, I mean, I'm just
I'm
serious.
okay, I think I'll take a deep breath and I'll go. Yeah, rest.
Mr.
I'm
Gadare, if
sorry.
you'll make sure.
Yeah, I'm sorry.
I'm the one that needs to make the
Yeah, I'm
decision, so I
sorry.
need to hear the case, so if you'll
Yeah.
make sure your direction turns me.
Has your child's behavior in your own residence changed after visitation with the mother?
Yes, she would be aggressive, she would act out. I'm not saying the child was like perfect, but she wasn't anything like this, really. Like school record will show it. They had perfect attendance, never missed
We're
school.
discussing in your residence at this
In
time,
my
sir.
residence, yes.
How has the child acted out in your residence?
She might like kick me, she will try to bite me if she gets upset about something.
Are these incidences isolated to periods of time after visitation with the mother?
Yes.
To the leading.
It's a question, Your Honor, it's not leading.
I'll roll that one. Will you rephrase your question?
Did your minor child's behavior, was she acting out in the same way prior to her having any visitation with the mother?
No, she was.
When did it begin?
After a few visits, after like the first, second visit, third visit, it was like a pure decline. And as soon as she started school, like they couldn't keep her in the classroom, she would run out of the classroom. As I said, she had lunch with the child one day, unsupervised. 2 days later, the child broke teacher's toe, and she kept saying everywhere, "Oh, child broke teacher's toe." And last year was a very hard year for me and for the child. I would get constantly calls from school, constantly, every day, come get the child. On Sundays, she would get suspended. On Sundays, I would just go pick her up. As I said, I used to use children's playroom as a daycare. They told me I cannot bring her anymore. And as 8-year-old, you don't want to live her by herself with another adult, so I was hesitant to get another babysitter for home, so it was really hard.
Without testifying as to anything an out-of-party witness stated to you, have you had to pick the child up from supervised visitation periods before with the mother?
Yes, I did.
When you were required to do so, what occurred?
Like in 2 occasions, the police had to be called.
Start with the first occasion, sir.
First occasion, I don't have the exact date, but the original monitor, Tracy Rose, said,
Sir, without stating anything that anyone else outside of this courtroom said,
okay,
just state what you personally witnessed.
okay. On one visit, Latasha Stevenson, she is the manager at Camelot, supervising the visit. I dropped the child, and about 15 minutes later, maybe half an hour, I can't remember, she texted me, she said, you need to come back, you need to come back. I'm ending the visit, Lydia is not complying, then I got...
Objection.
Were you required to go back to the visitation? Sir?
Yes, I had to go, I was playing soccer, I ended my soccer and I went back.
What occurred? What did you do when you went back? Where did you go first?
To the library.
And is that where the visitation was being
Yes,
held?
at the public library on Church Street.
How long had it been since you dropped your child off there?
About an hour maybe. Yeah.
And how long was the visitation to last, to the best of your knowledge?
2 hours is the visitation.
When you went back to the visitation area, who was there?
Miss Stevenson, Miss Hubbell, and the child. The police came later on.
Were you required to remove the child?
Yes, we had to.
Did you remove the child from the visitation early?
Yes. Well, what happened is, Miss Stevenson is saying the visitation is over. Miss
Objection.
Can't testify as to what
Okay,
anyone
she
else
wanted
said.
to end the visit, but Miss Hubbell was holding the child, not letting go of the child. So Miss Stevenson called police, and police came, and Dilara was grabbing her mother, and I told the police that please don't force her. I told Dilara, look, in more minutes it's gonna be over, then we will go. Then Dilara complied, and she said bye to her mother. Actually, I like court to see 3 short videos, Your Honor, from that.
Objection.
As a result of that incident, sir, did you remove the child from the visitation early?
Yes, I believe that we waited until the visitation finished, but there were like 3 officers waiting. Mother is sitting there playing her instrument, and child is crying, and it was very stressful. And Miss Hubbell wanted child to see that. She wanted child to see her mother getting arrested.
To the best of your knowledge, was the mother arrested on that date?
They didn't arrest her on that day. No. Actually, I think what I did, because I waited, I asked police to wait a few more minutes. I said, look, child is gonna let her mother go. You have to wait a few more minutes. Then she basically they separated, but we didn't forcefully remove the child. On the next visit, they had to forcefully remove the child.
What agency was supervising the visitation at this incident, sir?
Camelot.
And the next visitation that you state they had to remove the child, what agency was supervising that visitation?
It was life care.
On that date, do you know the date that event occurred?
I have to look at my text phone to find the exact date, but it was about a few weeks later they arranged the visit with life care.
And was that for the mother's supervised visitation?
Yes, at life care facility on Thompson Ave.
Where was that held at?
At the office of life care, they have like a room. They made it look like a living room arrangement.
And do you recall approximately what time you dropped your child off for that supervised visitation?
It was early morning. It was, I believe, it was at 9 o'clock.
And how long was that visitation period to last? To the best of your knowledge.
It was to be for 2 hours.
And were you required to return early to pick your child up on that date?
Yes, Supervisor Kenya.
Don't say what anyone else told you, sir. Just
Yeah.
answer the question.
Yeah, I had to go pick up the child early.
And when you returned to life care, what did you personally witness?
There was a police officer waiting outside. The door was locked. Then Kenya came and opened the door for us. We both went in. They told me to wait outside because of order of protection. I have to stay away from Miss Hubbell. And then the police officer went in, and I could hear Miss Hubbell was talking about then two more officers came. Miss Hubbell was still refusing to leave the property. She's saying visitation is not over until 2 hours is passed. But the supervisor is saying it is over, you have to leave. They told her. But two more, basically there were 3 officers went into the room. I waited outside. At that visit, they had to forcefully remove the child.
Did Ms. Hubbell refuse to return the child or to release the child?
I wasn't in the room. I haven't
Object
seen.
to the leading. And Your Honor, I think we're just now recycling the same testimony over and over.
All right, I'll
I've heard
sustain that.
removed 3 times.
Was Ms. Hubbell arrested as a result of this?
Yes,
incident?
she was.
Object to the, Your Honor, there is no.
What is the objection, counsel?
Irrelevance.
I'll overrule
When
that.
somebody has somebody arrested and then doesn't even
I'll
bother to show
overrule.
up, okay.
Thank you. Go ahead and answer the question.
Was Ms. Hubbell arrested as a result of this incident?
She was arrested. Yes.
And did she leave with the police?
I didn't want child to see it, so they first brought the child to me. They asked me to leave so they could take the mother out. They didn't also want the child to see her mother getting arrested. But Miss Hubbell wanted the child to see that.
But was the child present at the entire time these events were occurring?
Yes, when they removed the child was kicking, screaming, and biting. And I have the video from the library. I like the court to see those 3 short videos.
To the
Your
best,
Honor, but he's a witness, he cannot direct his own testimony, non-responsive.
to the best of your knowledge, sir, has the mother had visitation supervised with the child since that date?
Not that I know.
To the best of your knowledge, did Life Care refuse to continue supervising the mother's visitation after such time?
Yes, they refused. They said they won't supervise her visits anymore.
Do you have personal knowledge of any campaign the mother has undertaken in order to bring attention to this custody litigation?
Your Honor, that's irrelevant, the Court of Appeals has ruled on that.
It's not irrelevant, Your Honor.
Relevant
You-
as to a modification of, now I'll overrule that objection.
Do you have any personal knowledge as to any campaign that the mother has undertaken to bring attention to this legal issue?
Yes, I do.
Do you have any personal knowledge of the mother chalking certain areas of town with certain language regarding your daughter?
Yes, they.
And Your Honor, that was covered in the restraining order, and
This is a different hearing, so I need to hear the information too. I wasn't there for the restraining order. Unless you want to, concede the facts that were found within this restraining order.
well, I mean, we're here to modify the restraining order, it was, there were.
I mean,
findings
I'm
in
saying
the
I will let them move on if you concede the facts that they are.
Well, we can see that they have been reduced to an order that has not been appealed, so.
I'm not sure what, I don't have the restraining order in front of me. What are the facts that are stated in the
It's
restraining order?
huge off, basically.
Here it is. Okay, tell me again what you are conceding to from the,
That has been reduced to an order, and that we're not here to relitigate that order, we're here to.
But I think
to
he-
modify it.
I have not heard facts to what's in the restraining order, so he has the right to present whatever that same proof unless you want to concede to the facts that are in the order. he has the right to present. So let me just say,
I mean, whether I
will.
concede or not, they're gonna be in an order, Your Honor, so I can't
Well, not if
go
I-
to them without an appeal, so I haven't appealed it, and they're in an.
Well, I'll overrule the objection. I'm not sure if that got us anywhere, but I'll overrule the objection.
Do you
So he
have-
can't ask her about, he can ask him facts about.
I mean,
The information.
let me just, if I could be clear, Your Honor, in that restraining order, we were not permitted to put on any professional proof as to causation about this suicide situation. So there's a finding, of causation that we really don't agree with. But as to, yes, the rocks and the chalking and those kind of things, no, we don't disagree with that.
All right, so you're conceding that your client, as stated in this restraining order, that your client, all of the rocks, the chalk and the playground
Yes.
area, that
Yes.
she did everything that's in this?
Yes.
All right,
Now, what causes switch meltdowns and those types of things, we think is.
So
not before this.
Are we conceding all allegations that are findings, or all findings made in the temporary restraining order, Your Honor, or just the chalking?
I said, we concede that the conduct is conceded. The causation of the child's emotional meltdowns, we think is best for a professional and before this court as part of the modification.
Okay.
Yes, we concede the chalking, the rocks, all those, the facts. The only thing we don't concede is causation,
okay. All right, so Mr. Frakes, they have conceded to all of the facts that are within the restraining order, and having conceded all the facts that led to the restraining order, I don't think we necessarily need to question him about those incidences.
I would like to enter exhibits as to those, just for the record, Your Honor.
That'll be fine.
First, I would like to enter a copy of the restraining orders I made.
All right, that'll be exhibit number, we're starting fresh, so that's exhibit number 1
And does Your Honor have the copy?
of the restraining order. We do.
Thank you, Your Honor.
Oh, well, Your Honor, just kind of housekeeping then, could we move the prior exhibits into evidence and make it these pick up from there?
On opposing counsel's proof, she's welcome to do so, Your Honor. I'd like to be able to go forward and put my proof
Okay.
on.
Well,
Okay, I'll just do it then.
Okay, so this is exhibit number 1 is the restraining order from Third Circuit.
I'd like to present another exhibit to the court for entry into the record.
What is it?
I have one for you if you'd like to see it.
Please, before you enter it. If he can identify it, we're not going to object to it.
Can you identify this picture, sir?
Yes, I do, I can.
And what is this?
This is chalking at the Red Caboose Park in Bellevue.
And did you personally see this chalking?
Yes, I did.
Did you take this picture?
Yes. Actually, camp counselor, I believe this picture came from the camp counselor. My child was at a summer camp, field trip, they went to this playground, and my child saw this.
Where was this at?
The chalking says free Dilara gider cclj.org, TennesseeGen.com, children need both parents.
Your Honor, just going to object. I don't think he can personally identify.
Where was this at, sir?
This is, I went and saw this. This
Where
is it.
did you
Okay,
see
we don't
this?
object.
Yes, I saw
Withdraw my
it.
objection.
After they told me, after camp counselor told me.
Objection.
Yeah, you can't tell me what
Counselor.
you can't
Okay.
tell me what somebody told you.
After I was informed that my child.
Objection.
Yeah, you can't tell what.
Okay,
tell
I
him
saw
to inform the
this,
same thing.
yes.
Okay.
I saw
What location was this at, sir?
Red Caboose Park in Bellevue.
I think she's not, you are allowed to go on the evidence,
Right, without
okay.
objection.
She's,
I would ask that be marked the next numbered exhibit, Your Honor.
yes, exhibit number 2.
Mr. Goodere, do you have any personal knowledge of the mother posting signs regarding your daughter?
Objection, Your Honor, I think now we're just rehashing the restraining order, and we did say that any of those that are in the,
With the signs in the restraining order as well?
I think it's signs, chalk.
Displayed signs while outside of the school, Your Honor.
Okay, if that's in the restraining order, then I'll sustain that so we can move further. Unless there's different signs that were reloaded to in the restraining order, so that you may have a different one.
Has she done it since this restraining order was put down?
Not afterwards.
Okay.
I could present a exhibit to the court, Your Honor. Proposal counsel. Can you identify this sign, sir?
Yes, this sign was on a yard across the street from Galvin Elementary where Dilara goes to school.
And was this page taken off of the mother's Facebook page?
Yes, this is from Miss Hubbell's Facebook page.
But did you see this sign yourself?
Yes, I actually brought the sign here with me. It is a 2 feet by 4 feet. It's a huge sign.
And this sign was posted in the vicinity of your daughter's school?
Yes, across the street, like probably, like school is if this is the street, Your Honor, on this side of the school, the property is here, and basically anybody is driving can see that sign. And there were a bunch of other signs. I brought all of them.
What does the sign say, sir?
It says Free Dilara Gider, I believe. I cannot see it well, but I believe it said cclj.org, children campaigning against corruption. CCLJ.
I would ask that this be marked the next numbered exhibit, Your Honor.
Any objection?
No, Your Honor.
That's number 3.
Yeah, it says Free Dilara Gider, the sign. I can show the sign. Do you want to see the
We've
sign?
got the
Your
picture, sir,
attorney will
that
take
sign.
care of it.
And I collected signs that,
Mr. Gadir, please don't speak until you're asked a question.
sorry, sir.
Do you have any personal knowledge, sir, if your daughter has seen these chalkings or the signs?
Yes, she did.
Was her behavior altered at any point in time after seeing these signs? Did it vary?
Yes, after she saw this chalking during her field trip, next day I took
What
the,
was the date? I'm sorry. Date?
I can look up my phone. Tell me, please.
I would need to know a date if we're not trying.
Stay seated, Mr. Gadir. Your Honor, may he look at his phone to determine the date?
He may.
Where is it at, sir?
Over there on the table. Charges it. Thank you, sir.
See if you can determine what date the chalking was made, sir.
I believe it's August 4th,
August 4th of what year, sir?
2017.
After August 4th of 2017, are you stating that that's the date that your daughter saw the chalking as well?
Yes.
After that date, did your daughter's behavior alter any?
Yes. Next day, I took her to the same camp. She cried. She didn't want to stay, so I had to take her back home. Yeah, I couldn't leave her at the same camp.
Is that normal behavior for your daughter?
No, and they were planning another field trip to a swimming place. I can't remember where it was, but she cried and she was like very. She wasn't fit. She didn't want to stay. She cried. We had to go back home. I couldn't drop her at the camp.
To the best of your knowledge, has your daughter seen the signs that the mother has posted?
I'm sorry, I missed it.
Has your daughter seen the signs that the mother has
Objection,
posted?
that would be hearsay, Your Honor, that would be from the child.
That's to the best of your knowledge, has your daughter seen the signs that the mother has
I'm gonna overrule
posted?
that one.
But Your Honor, well, let me make another objection then. It lacks foundation. He hasn't testified that he would have personal knowledge without the child telling him something.
Picture of the signs have been entered into evidence, Your Honor. I would ask my client again, to the best of your knowledge, has your daughter seen the sign that the mother has posted?
I'll overrule the objection.
I don't know, but she saw another chalking at her soccer game.
Objection, a non-responsive. He can't start talking about another incident when he hasn't been asked. So
All right, I'll sustain that part.
What additional chalking are you discussing, sir, or addressing?
I have the picture in my folder. And
Just answer the question, sir. You don't need the
my
picture to
child
answer.
went to her soccer game in Bellevue. HYS soccer. She's in youth soccer, and during her first game, she went to game with her sister. At the entrance of the soccer fields, like all the kids go through that little bridge, a big red chalking said #free Dilara. Huge. Like,
What date?
let me look it up on my phone. This was August 26th, I believe, because I took the picture next day, August 27th, so it should be the prior day, August 20th. And I have a printout of this picture. It says, "Free Dilara." All her friends are going through that soccer field, saw this. Every parent saw this.
What was the date? I'm sorry.
August 26th. I took the picture on August 27th,
Of what year, sir?
2017.
After August 26th of 2017, did your daughter's behavior appear altered to you?
Yes, she didn't want to go to soccer, and when I take her to games, she run around a little bit, then she sits down, and
Did she cry?
she cried, yes. The sign said "Free Dilara."
Do you have any personal knowledge of hand-painted rocks that,
Objection, now that is all incorporated into the restraining order that the court has ruled is.
Your Honor, I guess what I'm trying to get in regards to that is, how do we get the exhibits in if we're gonna concede to everything?
I guess he's trying to lay the foundation to get the exhibit in. Do you
We
have it?
moved the restraining order in, if the guardian ad litem wanted to read it, I think she's had time since.
No, I think he's trying to get the pictures of the rocks in. Do you have any objection of the pictures
I
of the rocks?
do, all of that has been testified and hashed at length, and like I said, we were very.
This is a separate, this is the rocks.
It is in the restraining order, the rocks are in there.
Correct. The question is, do you have any objection for them to just introduce the exhibits? Because if not, then he does have to go through the question of laying the foundation of the pictures.
Of the rocks.
I'm assuming that's what he's
I mean,
building.
I guess that's.
Do you want to just show the pictures and see?
For something that's already.
My suggestion, Your Honor, if we're conceding to everything in that petition or in that restraining order, if we could do it as a collective exhibit for everything that's entered in, then that way that testimony doesn't get in. My only issue with that is for purposes of appeal, where we have been,
I'll just do them one at a time, but if they're conceded to the issues, then the rocks will be exhibit number 4, if that's what.
at lunch break, Your Honor, I'm going to get all the exhibits that I intend to enter that are referenced in the restraining order, and I'll
Perfect.
introduce them in order.
And let me see it
Perfect.
first to make sure.
That'd be
No,
perfect.
I will allow you to see them when trial resumes.
Well, then I can't, we can't say we time.
If you will let her see them beforehand, and then that way, if she has any objection, then y'all can hash it out, then when I come back on the bench,
Yes, Your Honor.
I can hear it at that point.
What concerns do you have regarding your daughter's mental stability with the mother?
Object to the relevance, his concerns with mental stability.
I think this.
Don't answer until the objection is addressed,
I'll
sir.
overrule that one, that's clearly in the statute at 366106 of emotional and mental health, so.
What are
I'll
your
overrule that.
objections with the child's mental stability if the mother resumes parenting time, sir?
Is it, can I state my
Your
personal opinion?
personal opinion based on your personal knowledge.
My personal opinion is mother is trying to harm the child, then can come here and say, look, this order is not working, you need to give me my child back. That's what my mother is trying to do. Doing everything in her power, even risking getting arrested to harm the child emotionally. So when the child shows signs of stress, then it blames it to others, it blames it on me, it blames it on court. Really, it is unjust to say that the child suffered because of the order from this court or because of the order from the circuit court. The child suffered because of what Miss Hubbell did. Yeah, I hope it is obvious to the court. I hope.
How has the child's behavior been in your care when the mother had no parenting time?
As I stated, sir, 2015, 2016 year, child had perfect attendance. She was on honor list. I have the copies of her awards.
How's her behavior been in your care, though?
She was good, but when she had those visits, her behavior went bad, and anybody interacted with the child can testify that last year she did horrible. She was identified as emotionally distressed. They couldn't keep her in the classroom. She would run out of classroom. All the kids were afraid of her.
Was it necessary for you to discipline the child when the mother was not having supervised visitation?
Sometimes I do, yes.
For what purposes?
She would she doesn't want to get ready for her school in the morning. It's always a struggle. Like she doesn't want to go to school now.
Were those instances decreased as compared to when the mother did have supervised visitation?
Object to the leading.
I'll
Final
sustain.
answer.
Child, can I?
No, but-
Stop.
no, you can't
Sir,
answer.
I'm gonna rephrase the
Mr.
question.
Frakes needs to rephrase his question.
When the mother was exercising supervised visitations, what was the child's discipline? Or what was the child's behavior?
She would get physical. She would scream, kick, try to bite me. She never actually bites, but she acts like she's gonna bite.
How is that compared to when the mother's visitation was suspended, sir?
Like this year, she started very good teachers. Hope they can come and testify here. She was getting all good colors. Like they were telling me, oh, she's doing so.
Objection.
I mean, she was doing so good.
Sir, when the attorney objects, stop answering, please.
Sorry, sir.
Answer the question as to the child's behavior in your care, not
Your
something
Honor,
else.
this, how is it with her and how is it with him has been asked about 5 different times, 5 different ways, it's just over and over and over the
I'll
same
sustain that.
questions
I
of
think we-
relevance.
How are the child's grades currently, sir?
She's a very smart kid. Yeah, she has always been good. Like she is reading Harry Potter book 3 now. She finishes like books. She give her 10 books. She reads them through in 2 days. Yeah, she's very intelligent. And
Have
her
you
grades
seen
are
her
good.
school grades currently?
Yeah, her grades are good. Yeah, there are no concerns about her grades.
What are her grades currently?
I can tell you the exact grades, but they are all good.
Last grading period, what were her grades?
I don't remember, sir. I look at her grade chart, but I can't remember. But they were nothing that stood out for me to be concerned about her grades.
What were her grades during the 2016 school year?
2016-17 year.
Yes, sir.
Her grades were okay, but most concern was her behavior. That has been the case with our
So, Frakes, I probably should have stopped you right before. We're right about the time I need to leave. I think that clock's a little slow. Is this a good
For
stopping
lunch,
point?
Your Honor?
Yes.
Yes, Your Honor.
And Your Honor, may I, look through the exhibits that were entered in May on the break? If I won't take them out, I just need to look. They're in the record.
Can you sit in here while she's looking at them?
Yes, I can do that, ma'am.
Yeah, if you will, we're gonna send you down with Miss Francis downstairs to do it
That's
downstairs.
great, that's fine.
So I gotta get them lunch too.
All right, thank you.
All right, we will, be in recess to about 1:30.
Was in recess at 1:30.
No.
See, these should all be the same.
We see Connie told me a little bit out of order.
Well, yeah, I'm gonna have to come back in order.
We're gonna watch.
And let me, but they're all